today, and if I could introduce Will Tishkoff of the Michigan Bar, who will be arguing the case for the appellant today.
All right, thank you, Mr. Huff, and good to see you. It's been a while. Okay. Good morning, sir.
Good morning, Your Honors. And I'm very honored to be before you today.
We're glad to have you with us.
First time in this courthouse, beautiful. My office is in Ann Arbor. We have great counsel here. Hope you won't hold that against me. So.
We'll try not to.
Okay.
We certainly won't hold it against your client.
As long as you don't do that, I'm okay. You can take it out on me. That's not a problem. I do want to reserve, if it's okay, 5 minutes.
5 minutes for rebuttal, yes, sir.
May it please the court, I represent the appellant, Middleburg Real Estate Partners, and if it's okay, I'll refer to them as MREP, as we did it in trial. The appellee is Gresham Smith and Partners, LLC, and I'll refer to them, if that's okay, as GSP. I know that we have the briefing here, and the court has read the briefs, and I want to try to hit on some main points about the facts and a couple key documents, and then certainly any questions the court has. The original contract, whatever that may be, was countersigned on April 6, 2016. So the original work to be done at Millwood was contracted then. Now there was a engineering services proposal sent that is dated April 4. It's a letter. It refers to the attachments, the exhibits there, and it has the terms and conditions in that document. These are all sort of separate documents which make various references, not real well put together, which is an issue. In any case, my client clearly rejected that, and that was not disputed at trial. Our client, was not going to sign that agreement. We utilize our agreement, which has certain things in it, like where to send the bill, because we're in Virginia, and we need to be able to approve what's actually done.
But you did say you put it on top of the things that Gresham and Smith sent you.
That is true, Your Honor.
And so their proposed agreement is part of that attachment. So what are we to make of that?
Exactly, Your Honor. And there is the conduct of the party, which is a bit confusing. What I'd like to bring to the court's attention is the judge found that it was laid on top, that this contract, everything was on top of these terms and conditions. Now, they're very inconsistent, and I don't believe the consulting agreement actually says this document laid on top is incorporated in. But in any case, if you look at their terms and conditions, they have an integration clause. If you read it carefully, it's almost at the end. It says this document consists of, and it names the letter and the attachments to the letter. It does not reference the consulting agreement. And I think legally this becomes pretty significant because it's impossible to reconcile this document, which says in the integration clause, it does not include the consulting agreement. But, you know, definitely a point at trial, and the judge found
it says specifically we don't include the consulting agreement, or does it say we don't include other contracts?
Your Honor, I've gone over it very carefully. And, what it says is, and it makes specific reference, Article 8, Exhibits and Special Provisions. Exhibits included Exhibit A, the engineer proposal, Exhibit B, engineer services, Exhibit D, which tracks perfectly what they submitted because there was no Exhibit C. Exhibit E, schedule of hours, makes no reference there to the consulting agreement, and then says, this is the total agreement consisting of pages 1 to 5 inclusive with these exhibits identified above, constitutes the entire agreement between the client engineer, supersedes all prior written oral agreements, can only be amended or modified and canceled by a duly executed agreement. So, Your Honors, I do believe that that's significant. To try to reconcile these documents is very, very difficult. Different provisions, different terms, et cetera. Now, the parties wanted to do the work, and my client signed the counter document because she said, I'm not going to sign yours. They signed the counter contract, which you can see in the consulting agreement. We didn't sign these terms and conditions. The other side originally signed it. There is no countersignature. Taking the facts all put together, Your Honor, I think it's very clear that you can't merge terms and conditions in. Let me just say then that there is this document. Our document is countersigned. It says it's effective April 5. Now, there's this requirement for mailing the invoices, the invoice at MDGB, which is the invoice in Virginia where Rachel Noon would review the invoice. And it says, or you can mail it to Rachel Noon. Now, Gresham was fully aware of that, and the first 5 invoices were properly submitted. What's very significant is the timing. We get into the project in the fall of 2016. This is when, October, November, work stops on the project, and the order is given to cease work. That's not disputed. Work was supposed to stop. Now, what ends up happening is there is additional work that GSP wants to proceed with, and it is outside the scope of the work that was in the contract. Now, the contract, which everyone agrees we're following, the terms of the consulting agreement, the counter contract says, if you're going to do additional work outside the scope, it has to be in a written authorization signed by my client. That did not happen. And the dates, I think, are very important. If you look at there's 2 invoices at issue, and there's 2 change of work orders. Exhibit D15 and D16, these are the key change of work orders. If you look at the first one, change of work order, actually, they're both on the same date. So we have 2 orders. They're dated October 27, 2016, both of them. The proposal date, which is only signed by GSP, is October 31. So it's after that date. The requirement was to bill monthly for prior work. The 2 invoices at issue are October 8 and November 8. The last date for professional service to be billed was through October 25, 2016. Work had stopped. So the testimony is that somehow we authorized it, we approved it. They went ahead after the work was done and put a date in the document of 1031. There's no signature by my clients. It's contrary to the contract. Now, Matt Evans was the person there. The contract's clear that he hasn't, somebody's going to sign this, which he didn't. He's not called to testify by the other side. And I think it's undisputed that there's no evidence that there was ever proper authorization for these change orders. Now, my client, months later, actually gets the invoices. We now go all the way, excuse me, just get the exact date here. We go all the way to...
Well, didn't the invoices go to some email address other than a person at your client's office?
That's critical. The subject invoices, which finally were submitted after the closing on the project June 6, those did not go to the email address that was required. The argument the other side of trial is somehow these were approved even though there's no written approval on them. I don't think there was any material evidence they were approved. So months later, for the first time, they go to this invoice email. But this is very significant, Your Honors. They're sent twice on June 6th. It is Exhibit D11, twice on that date. And the first time they're submitted by Don Williams. He knows we're closing on the property. We made sure to reach out, find out what invoices are outstanding. We had none at our offices under the invoice, and that's why there was no basis to pay. Not to mention, we have the problem with no written authorization to change orders, no evidence that any of this work was approved or even that it was properly done, because we're not out there. So what happens is on the 6th at 124 is when Gay Osborne sends altered invoices. Everyone agrees they've been altered, so they look like they're sent to the original invoice. In the morning, we've got Don Williams sending the non-altered invoices, but not to the invoice box. So, Your Honor, we've got a very material term in the contract so that we can make sure the right work is paid for. The other side sends the first 5 invoices knowing where the email address is. At the end, when work ceases and there hasn't been authorization and running to do the work, they go ahead and they put these various dates on here that make no sense. change order they say was authorized that wasn't even submitted till after the work was done. I think that on its face is highly significant. Now, when we have a demand made to us, and we're looking at altered invoices, and that seems to be the method.
Did Mr. Finlay discuss all these invoices? Is that the person who did that for you all?
He testified at trial
Right.
that the first time he had any intercourse, any discussion, was right before the closing, and he reached out to Don Williams.
Well, the court found he didn't really have a lot of knowledge of the interaction between the parties, didn't she?
Well, he is the person that is responsible in Virginia for everything that happens.
Yeah, but Mr. Evans was the one that interacted all the time with Gresham and Smith, correct?
Completely agree. He was there day to day. He was not called as a witness because there was no evidence that he actually approved the subject invoices, and it's because it all happened at the end. Matt Evans eventually left before this even came up, but Chris Finley did reach out before the closing and said, I need to have the invoices and know what is not paid. It was only after the closing that they went to the invoice.
So what effect does the court crediting Mr. Williams for Gresham and Smith, I believe that was his name?
Don Williams, I believe, Your Honor.
Much
Correct.
more so than Mr. Finley have on your argument here about the invoices.
Taking what was presented at trial at face value, you can see the transmission from Don Williams. And Chris Finley on our side didn't have the invoices to approve. They went to the correct invoice address after the closing, and the original contract says you have to bill within 30 days. They were altered. And if you look at the testimony of Mr. Williams and the emails, that is not properly sent to us. Again, on the day in question, Don Williams says, oh, you're having a closing, you had a closing the day before, here's the invoices. He doesn't send an invoice, sends it to Chris Finley and others, now wanting to get paid. A few hours later after the closing, we get altered invoices at the right address, which I think is evidence that they knew it had to go to the invoice address. So we believe, Your Honor, look at the testimony, look at Mr. Williams' testimony. I don't think it amounts to abiding by the contract. I think it amounts to actually playing games, altering invoices. And I think my client acted in a sound way. We get on the same day, June 6th, 2 different sets of invoices. There's not a change order indicating they've actually been authorized. The contract cannot be disregarded.
The alteration that you keep referring to, that was just of the date, wasn't it? Or was there more?
I don't want to misspeak, Your Honor. There was a change in where it was sent to. There were a couple other alterations. The court said they were just being updated.
That's
Right.
why I was getting into it. You claim they're alterations, and that makes it sound sort of sinister.
Well, I guess I am suggesting.
And the court said that they were just updated.
I guess I am suggesting that, Your Honor. I mean, it was intentionally done so that it would look like it was sent to the correct address. I don't have it in front of me now. I thought there were a few different things done to it.
Okay,
Now, the
well-
court took the position that it was an update. But how do you update on the same day that you send the marked up invoices? I think my client has a legitimate, well-founded belief in the contract that they are not following the contract, that the reason for having the requirement for where to submit the email, which was known to the other side, was very significant, because that's how we find out if the work,
All right,
the
your-
work
Thank
was
you.
done.
Your time is up.
Thank you very much.
We'll hear from you further on rebuttal. We'll now hear from Gresham Smith. Good morning.
Your Honors, my name is Vic McConnell, here of the Nashville Bar with Smith, Cash and Orr, and I have the pleasure to represent Gresham Smith in this matter. I guess I should have stated, may it please the court. Can I begin my argument at
Sure.
this time? This case, it's a sour grapes case. It's a sour grapes case.
On whose
defendant-
part?
I'm sorry?
On whose part?
On the default part of the defendant. Didn't like the outcome of trial. Didn't like the fact that the court gave no credibility points to their witness at trial, Mr. Finley, and decided to contrive a reason to appeal this matter. What's at issue, really, in this appeal? First of all, the trial court was exactly right. The credibility weighs drastically against Middleburg in this case. You probably will have an opportunity to read that trial testimony of Mr. Finley. He had absolutely nothing to do with this project from day one. My client didn't even talk to Mr. Finley until the June timeframe when, as a last resort, he reached out to try to get Gresham's invoices paid. Second of all, the contract that's being disputed as not being the full contract is just wrong. This was admitted. This wasn't even an issue at trial, even though it was Mr. Tishkoff tried to raise it at trial, because it had already been admitted that it was the contract as part of the pleadings. And that's significant.
So you're saying that they admitted that Gresham and Smith's contract that was included in its April proposal was indeed a part of the overall agreement.
Exactly.
Now, opposing counsel said that in the list of exhibits in the contract that was laid on top of everything, they omitted listing your Gresham and Smith contract. Is that correct?
I disagree with that. I disagree with that.
Okay.
The master contract, I'll just call it the master contract for lack of another thing to call it. They received Gresham Smith's full package of proposal, hourly fee schedule, and the terms and conditions. Middleburg received that complete package through Matt Evans. And you'll see, if you just look at the first half a dozen exhibits, trial exhibits, you'll see the email correspondence where that complete package was sent to Middleburg, to Matt Evans, and Matt Evans returned it, the complete package, with Middleburg's master contract document on top of it. None of those other documents that became exhibits to the master contract were required to be signed once they were incorporated by reference into the master contract. So.
And how was the document at issue incorporated by reference?
It was attached to the master contract, and there was language in the contract, specifically under the contract scope provision, that states, that refers to, well, let me just read it right here. This is under the contract scope. This agreement, together with the attached exhibits and or attachments, constitutes the entire agreement between the owner and the consultant. That's within the master contract. And attached to that master contract were all of these exhibits that became a part of the master contract. So when they sent that back to Gresham Smith, executed, all of those attachments were
So the
attached to
fact that they might not have mentioned it specifically, and they mentioned other things specifically, that fact doesn't matter.
It doesn't matter. Matter of fact, I think what Mr. Tishkoff was reading from was Gresham Smith's proposal, not the master contract that plainly says anything attached here to constitutes the entire agreement between the parties. And it was undisputed. They admitted it with their answer that yes, the contract you attached to your complaint is the contract between Gresham and Middleburg. So we have that element. We also have the element of all that's really being disputed as part of this appeal, in addition to the attorney's fees award, is the court's award of $38,000 to Gresham. The invoices included much more work that had not been paid aside from the $38,000 that the court also awarded. That $38,000 was part of the original scope of the contract. It didn't require a change authorization. If you look at the contract itself, the contract scope, which was better defined, so to speak, and broadly defined by Middleburg, states that the consultant shall provide the services, including without limitation, providing any documents or submittals requested by owner or any governmental entity having jurisdiction over the project. The whole purpose of this contract was to get approval for the development of this property. And the owner knew that. The owner knew, well, we have a proposal here. We know we have some scopes of work that have to be done. There's some other scopes of work that we don't know what will exactly the level of work that it will entail, but we want that included in the proposal. It's okay that you don't have a number you can give us right now, but what we want to make sure happens is that you do everything that you're requested to do by either us or any government entity having jurisdiction over the project, and that was Metro. And my client did just that. All with the approval and blessing of Middleburg. Now, they dispute that Matt Evans had the authority to provide the blessing of Middleburg, but that's completely contrary to the facts, completely contrary to the proof at trial. Matt Evans signed multiple contracts in this case. He may not have signed this contract, but he signed a surveying contract. He also signed, at the time they closed on this property, the purchase agreement for this property. How does Matt Evans not have authority when he's out there signing very important contracts? When this property was sold to another developer, Matt Evans signed the closing documents. Matt Evans had all the authority in the world. The work was performed in pursuant to his request, his knowledge, and pursuant to this contract.
But it wasn't in writing,
The
work that we're talking about here. The change
Our
orders.
position is it was in writing. It wasn't a change to the contract.
It wasn't a
The
change,
contract
okay.
included,
The 38,000 was not a change.
it was not a change.
Okay.
The contract scope, if you look at the contract documents, it referred to this item of work as being a future proposal. Well, Middleburg had already paid one of those work items already, the traffic study. The traffic study is also listed as a future proposal. Gresham was directed to do it. They did it. And in order to show Middleburg what cost, what effort was included in that, they provided their documentation and put that cover sheet on it. But it by no means was meant to insinuate that we think this is changed work. It wasn't. That was paid. The fact that that was paid, even if a PSCA was considered changed work, they waived the requirement for written approval because they previously paid for changed work under their argument without written authorization ahead of time.
So there is, in the record, proof that similar requests for payment were paid, even though they weren't through change orders and they were just to Mr. Evans and he approved them.
Because
And that's the Mr. Williams testimony
Yes, Your Honor.
that the court approved specifically?
Yes, Your Honor.
Okay.
That's the credibility determination that the court made in that respect. And so with regard to these 3 invoices that originally weren't paid, they weren't paid. The September invoice wasn't paid for 9 months. The reason it was paid eventually is because of this telephone conversation that happened between Mr. Williams and Mr. Finley. Mr. Finley was trying to unload this project to another developer. And the reason he wanted to do that and the reason he was able to do that is because Gresham had already gotten all of the Metro approvals that were needed to develop this property, which made it a very attractive piece of property for another buyer. But what Mr. Finley didn't want to do was pay Gresham. And he had this phone conversation with my representative, Don Williams, and he was told in that conversation, how much was owed to Gresham. Instead of paying all 3 invoices at that time, and this is the June time frame, he paid the 1 invoice. And then he tried to assert, well, I don't have to pay the other 2 invoices because they were never sent to the proper address.
But the September invoice wasn't either, or
The
was it?
September invoice was sent to the proper address
Okay.
and never paid. They had no intention of paying Gresham. Okay, but when they realized that they couldn't assert the same, what they contrived as a defense, that it wasn't sent to the right address, they went ahead and paid September. They refused to pay October and November. So when Gresham caught wind of this technicality, what did Gresham do? They said, okay, we'll change the invoices, we'll alter the invoices to reflect the email address and the person, Rachel Noon, at Middleburg's home office, and we'll resend them. That's it. That's all they did. It wasn't an alteration in a cynical sense. It was an effort, okay, if that's your position, then we will send them to the invoice address. Why? It's equivalent to cure, right? If you're going to claim that as a defense, which we say is not a defense because there was nothing in the contract that made sending an invoice to this address a prerequisite or a condition precedent to payment.
Counsel,
So-
wasn't it untimely at the point it's sent in June, though? I mean, there's a requirement in terms of billing within a certain time period. Is when it's finally sent to the right address, isn't it late?
It's not late in this case, and I'll tell you why. Those invoices were sent to Matt Evans at the time they were generated. There's extensive correspondence in the trial record in the form of exhibits of back and forth communications between Don Williams and Matt Evans about these invoices. Matt Evans had them. He requested a copy of them again. They had discussions about them. He never objected to them. They had the invoices. The boots on the ground guy for Middleburg had the invoices. It wasn't until Finley got involved in June when he wanted to flip the property to somebody else that those invoices were objected to. And the only defense there was that they were not sent to the correct address. They were timely delivered to Middleburg, without a doubt.
Now, weren't the invoices sent to an address, invoice@mbdgc.com originally?
Some of them were, yes. Some of the original invoices were
But you said they
sent to
were
that.
sent to Matt Evans.
But these 2 invoices were sent to Matt Evans. That was, Your Honor,
Okay.
it was a clerical mistake.
All right.
Gresham didn't even know that there had been a clerical mistake because Matt Evans had continued to have communications about these invoices. It wasn't until Mr. Finley got involved that there was an issue with the delivery. So what did Gresham do? Okay, if they need to be delivered to this email address before you pay them, then we'll do it. And so they altered only the address on those invoices. And those are very carefully, you can compare those 2 as part of the exhibits that are part of the record. So, even after the invoices were originally delivered to Matt Evans, delivered again to this invoice address at Middleburg, Finley refused to pay them. Wouldn't even pay the undisputed amount, just refused to pay the invoices, which resulted in us having to be here in this.
Were there any invoices that were sent to Matt Evans and not the invoice address that Judge Clement was referencing that were paid by Middleburg here? Did they pay any previous invoices that were sent to Matt Evans?
Your Honor, I don't have those invoices in front of me, but I believe the record will reflect that the answer to that is yes. But I cannot recall, and I don't want to go on the record and make that mistake. But again, I want to emphasize the contract itself did not have a clause in it that made submittal of invoices to that invoice email a condition precedent. And we all know under some of the case law in Tennessee, unless the contract requires something labeled as a condition precedent, then it's not assumed to be a condition precedent for payment. The pay when paid clause in construction contracts is a good example of that. As far as the attorney's fees, there are 2 clauses that cover attorney's fees. The court was well within their discretion to award attorney's fees in this case. Gresham was the prevailing party, and the court did so and did not abuse its discretion in doing the attorney fee award.
All right, thank you, Mr. McConnell.
Thank you.
Mr. Tiskoff, your rebuttal.
Thank you very much, Your Honor. Well, Your Honors, if I may, let's quickly start at the attorney fees, but I'd like to get back to some of these arguments here. The attorney fee award was far greater than the $72,000 being argued over, 120 to whatever. The court pretty much gave absolutely everything that it could. The factors are there. You know, you can look at the factors. We've shown where there was some billings that are questionable, but fundamentally, the court made a statement that this case has gone on for years. I would like to point out that it was timely pursued. There was the pandemic and a change of judge, which added on a huge amount of time. We certainly didn't like that. There was another extension because the other side had a witness, not ours. And we said, fine. So I've just ask the court, and I know you will, if you look at the standards and how the court came to this determination that there should be this kind of money awarded, I don't think it follows the standards in Tennessee for awarding attorney fees. I would like to turn to a few of these comments here, Your Honor. And there were questions asked that I think were very significant. They knew the requirement of the invoice address. They knew that we needed that in Virginia to actually pay, and it was Rachel Noon who was in charge of that. Yes, the first 5 went to the invoice address, and they knew that. The breakdown was in October and November, when my client, and this wasn't the whole case about this, but they didn't get the timely zoning permit, so we couldn't proceed with the project. We certainly would have liked to.
Counsel, I'd like to ask you the same question I asked opposing counsel, which is, were there any invoices that were sent to Matt Evans, not the specified email account, but to Matt Evans, that were paid by your client prior to the 2 that are at issue here?
I do not want to misspeak. I do not recall that right now. But I do not want to misspeak, just like opposing counsel. And in the record, we have everything there. Matt Evans didn't testify at trial, and I think this is very significant. These change of work orders, they are all misplaced chronologically. And the $38,000 is specifically in a change of work order, and it's in the invoice listed as a change of work. So it's not clear from their proposal what is and isn't, but we needed some kind of documentation that we'd actually authorize the work done. And Mr. Evans, after October 31, where we have these unsigned change orders, the emails show that he's asking Matt Evans to please sign it. After this date, it's never signed by Matt Evans. The one invoice that was paid, when we reached out before closing, Rachel Noon found there had been a submission to the invoice box. So she said, yep, and paid it.
That's the September one.
I'm pretty sure. There was one, that one she
The one
paid.
that was paid.
The one that was paid.
Of the 3, that was the September
She
one.
found, yeah, I did get it. So she paid it, and we tried to find out. Chris Finley reached out. I need to know where the actual outstanding invoices are. Don Williams didn't send Chris the actual invoices when he reached out. He just sent him saying, you owe us $72,000. My client gets it for the first time at the right address. Rachel and Chris only saw all of this on June 6th, substantially after the work is done. I'd like to quickly move to this issue of competing. I'm sorry. Yeah.
But Evans did see them. Is that not? Doesn't the evidence show that Mr. Evans received these invoices and asked questions of Gresham and Smith about them way before your clients say they ever saw them?
He did not testify at trial.
Right,
But
there was testimony, and I believe he referred to emails that went back and forth about these very invoices between Mr. Evans and Mr. Williams. Is that correct?
I'm agreeing about those emails. I'd ask the court to take a look at them, because it's where Mr. Williams is asking, Mr. Evans, I need to get these signed. Now, the project wasn't done properly by Gresham. They knew that. Part of it, the key thing was getting these permits, And they decided that they were going to go ahead and do this various work, even though it was ordered not to be done. Then they scrambled to get a signature on the authorization. How do you backdate? You have a bill through October 25. The first time they have any proposed change orders at issue here is October 31. And the emails you're referring to are asking Matt Evans to sign. He does not sign. I mean, look at the record. There's no signature. Your Honors, the contract has a meaning, and we would suggest when parties contract, you can't exclude that. The unjust enrichment was dismissed, Your Honor, because they knew there was work outside the scope. If you put these two contracts together, they're completely contrary. The judge, give her respect, she picked and chose what provisions. And I don't think you can render a contract meaningless. We brought a motion for unjust enrichment because we knew that what they were seeking was never approved. That was dismissed. There's a reason they brought it. I would just ask the court to look at the record, look at all these misstatings, look at the unsigned document, and we just ask for the contract to be upheld. And thank you very much, Your Honors. I really appreciate your time.
Thank you very much. Thanks to both of you for your arguments. We'll take your matter under advisement. Call the next case, please.
Connie Regulay versus Rogers Anderson.